Good evening. My name is Tyler Lattimore. I am the director of the Heirs Property Clinic at the University of Florida's Law School. I'm going to talk to you today about the clinic, but before we get there, let's talk a little bit about what probate is and how it's useful in the heirs property space. Is that okay? So, first, the first question is obviously what is probate? The simple way to put it is that probate is a court supervised process and by which the court helps the family or of and the heirs of the decedent decide or understand what property, identify the property, gather the property if necessary, and go through the process of distributing property that was owned by the decedent being the person that is deceased. Also, a part of this process, the court helps supervise the process of identifying any people that are creditors of the property of the decedent, the people who have or hold debt of the decedent. The simple way to put it is this little timeline I have here. What we see typically in that first grace circle is someone passes away. Then we take the time to acknowledge the death of our loved one, go through the funeral process, and bury our loved one. And once we have the ability to do that, we then take the time to go to the court, and the court then supervises the process of identifying the property, identifying debts of the estate, and then deciding who appropriately would get the property under the proper will or the statutes of the state of Florida's intestacy statutes. We'll get into detail about that in just a minute. But first, it might be helpful to identify what property we're talking about when we say assets that are under the probate, so-called probate assets. Those would be bank accounts, investment accounts, things of that nature, but as well as vehicles, whether it's a boat, a car, a truck. Those vehicles will be included in the probate as a probate asset, but also personal items, personal effects. If grandma had a nice ring that we always saw her wear, or a nice necklace, if there's artwork in the home, those would be probate assets as well. And then, generally speaking, the property such as farms, vacant land, and other property also falls within probate property. We have a little asterisk here for homesteaded property. It falls outside of probate, but there is a process that we still need to go through in order to make sure it's properly transferred. And I'll talk a little bit more about that. And then on the other hand, you have the debts, the things that we would need to address through the probate process in a lot of the cases. And that would be things like funeral expenses, medical expenses, especially when the loved one died in hospice care or something like that. That would be needed to be addressed in the probate process. And then, of course, consumer debt, credit card debts, things like that would also need to be addressed in the heirs property, excuse me, in the probate process. The next question that comes up is like, what actually happens with the stuff, right? The stuff that mom or dad or grandma left behind. So the question is answered in two ways to start. First of all, the question is, did the person pass away with a will or an estate plan? Right? So if we are in a situation where we have probate assets, the ones that we talked about just a second ago, and the person has a will, a valid will that was executed before death, the assets, generally speaking, would pass in accordance with that will. We have situations where people are in the other category, the intestate category. That means they died without a valid will. The key is that valid will portion, right? We have some people that try to go through the process on their own. They draw up some kind of document and think they're all good to go. When we start the probate process, the court's job is to look at the actual estate plan, the actual will that the decedent executed before they were deceased. If the case is that that the will isn't properly executed or doesn't cover sufficiently the probate assets that the court needs to deal with, that person could still be intestate. We have situations where people don't actually go through the process at all and then end up in a situation where they are intestate. And luckily, or not luckily, depends on how you look at it. And most of you probably would look at it like me in a bad way, but the state then decides what happens to your assets if you're in a situation where you did not or do not have an estate plan upon death. A lot of people hear that and they think, oh, that means if I don't have a will, that means that the state is going to take all of my property. I get that question a lot, and the answer is Not really, no. That is a situation of last resort when there is no one else in your family, you died, and you were the last person in your line. That's the only way that comes up. There are 3 scenarios that are typical for families to deal with that I wanna talk about so that we kinda understand what we mean about intestacy, the order in which people receive property when we pass away and we don't have an effective will. The first situation is one where someone passes away, they don't have a spouse that survives them. Either they were never married or they outlived their spouse. In that situation, the children would just be left behind. And in that situation, as we would expect, the children would split the assets evenly. The second scenario is when slightly the opposite happens, where a person passes away and all they leave behind is their husband or their wife and no children. Again, as you would expect, we would see that the surviving spouse would receive the entire probate assets. The last category is that I wanted to provide as an example is when you have a blended family of sorts. This is when you have a spouse that marries after a person already has their children. So let's take Frank for example. Frank marries Sally. Frank already has a set of children. Sally has no children. Frank passes away, and in that situation, what we would expect to happen is that Sally gets 50% of Mr. Frank's assets, while his children share the remaining 50%. That's typically what we would see. So that's just a few examples of what happens when we go through the probate process and who gets what. Next question is obviously, well, how do we start a probate? You've talking about how it ends up. How do we get there in the beginning? So after we've gone through the process of grieving our loved one and we are ready to go to court, we file what's called a petition. That lets the court know that you're asking something for them to do something. And there's a few different types of petitions, general petitions that we will talk about in a second. But just to understand how we get it started, first you fill out the petition, hopefully find an attorney that can help you do so. But you fill out a petition and then you take it to the clerk of court either by physically going down there if you're filing in Lattimore County, that's just downtown right off you the Bo Diddley Plaza, or you can mail it, or if you can, you can file it in the through the Florida e-portal system online. Question about where do you file? Generally speaking, you want to file a probate, start the process of filing a probate. You want to file that petition in the county where the person resided. They could be on a trip and they can pass away in Marion County, but if they resided in Latrimore County, you want to file that in Latrimore County. The situation comes up where someone has an interest in land, right, in Alachua County, but they lived in Georgia or Alabama. In that situation, you need to file that probate here in Alachua County if the property is located in Alachua County in order to deal with it. So if they are out of state and you're dealing with property in the state of Florida, you want to make sure that you're filing in the state where the real property is located in those situations. And we'll talk about this a little bit more, but the fees to file probate is there's a range from about $231 to $400 in the county. So we'll talk about what that looks like going forward. I just want to flag that if that is a hardship for people, the clerk's office does a good job of determining whether or not people are indigent, meaning that they can't afford that cost. So if that's your case, you'd be able to apply and get a waiver as well. So the main type of process that people go through is formal administration of an estate through the probate process. This is a little bit more difficult, and I'll flag even at the beginning that this process requires that you have an attorney. When do you need to go through formal administration? Generally speaking, when you have assets in an estate, the things that your loved one owned, if that if all those if you add all those properties, add up all those personal effects, if they come up to 75 of over $75,000, you have to go through formal administration if the person passed away less than 2 years ago, right? So the $75,000, it includes everything in the in the probate assets, which excludes the homestead, right? So you can have a situation where people have $150,000 worth of assets in their homestead, actually their property, right? And then $10,000 in a bank account. In that situation, you ignore that $150,000 house, because it's homesteaded, and just look at the 10,000, and you could potentially use a form of administration. But the key there is also to look at if the person passed away less than 2 years ago, right? The other situation might be where you need a personal representative in the probate process. And again, in that situation, you want to go through the formal administration. Again, you need an attorney to do this. Filing fee here, it's a little bit more complicated than all the other avenues we can go through the probate process with. So this fee is $400. But again, there is a process to get that waived. Summary administration, that's my bread and butter. This is a situation that allows you to more strategically figure out how you can go through the probate process and save time and save a little bit of a headache when you go through this process. This process requires an either or situation. Either the person has been deceased for longer than 2 years, you can go through the summary administration process. It has a lot to do with creditors. Don't need to really get into that tonight, but generally speaking, if they passed away longer than 2 years ago, you're good to go through the summary administration process. Additionally, if even if they've passed away less than 2 years ago, if the assets, again excluding the homestead, are under $75,000, you can still go through summer administration. Again, you want to think about creditors. Still, if they have consumer debt, you still want to think about that, and you still have to consider those interests in the estate, but you still can go through the summer administration process. This one, as far as the filing fees, it ranges. If the assets are generally less than $1,000, the cost to go through this process is $235. If the assets are more than $1,000, generally the cost is $345. One more slide, I'm sorry, if you can go back. All right. The last situation is the homestead, right? We know that homestead property has special status in the state of Florida. The state of Florida has some of the best homestead laws in the country. So in this position, it's basically saying, hey, court, I have this asset called the homestead that technically falls outside of probate, but you still need the probate court to help you get to a place where that homestead is properly transferred to your heirs or to your beneficiaries in accordance with either the will or the intestacy statute, so you can avoid some of the issues that Ms. Range was talking about. This petition really asks the court to do three things. First, it asks the court to identify the homesteaded property as actually mom's homesteaded property when she passed away. That's important to say, hey, court, this is homestead property. The second thing is to say to the court, for the court to determine and make sure that that homesteaded property passed along automatically when mom died to the heirs. The third thing is to say, well, along with that homesteaded property came the constitutional protections for homestead property. Chief among them is the idea that the homestead exemption, no, sorry, the homestead protections from creditors continues to pass through the family. And while you can use that process to go ahead and get your own homestead exemption, it is important to realize that that homestead that mom had is mom's, and you need to get your own, and you need to make sure that you're letting the county property appraiser office know that. And this filing fee is a little bit more simple, is a little bit lower because the process is a little more simple, and that is $231. Now, quickly, I want to talk again about the Heirs Property Clinic, and this is the organization or the clinic that I am the director of. I work with somewhere between 10 to 12 students every semester in our projects, and we help to serve the community through really three ways. First of all, clearing title, doing some of the work that Ms. Range talked about to make sure that families understand the process and get the legal help that they need, and do so for free. That can be probate, quiet title, and also just providing consultations to family as necessary. The second category is the prevention side. again, things that Miss Range was talking about, and I think some other people are going to talk about. So I won't go into great detail about that. But that's really just making sure that you have plans in place to either avoid the heirs property issue, or if you're already in the heirs properties position, to make sure that the generations don't grow quite as quickly and quite as large as they would otherwise without a plan. And then lastly, the students and I, we go out into the community and do things like we're doing today, which is to basically explain about the heirs property issue and provide some resources in real time at different houses of worship or in other community organizations as well. The clinic is a partnership that we have between the city of Gainesville, obviously the property appraiser's office, and also Three Rivers, which you'll hear from as well, to make sure that we are able to cover as much as we can in trying to help and serve the community. There's three things really you need to think about when we're trying to see who actually qualifies for our assistance. The first thing is we need to make sure that you have an interest in property. Doesn't necessarily have to be heirs property. It can be your property in your name. You're just trying to come up with a plan. We can serve you. The other thing you need to think about is where the property is located. We serve people with interest in property, even if they live somewhere else. If they have interest in property in Alachua County, in Gainesville, we can assist, generally speaking. The third one is also very important. It's dependent on your income. There's a cap that we have. There are two caps that we have. We kind of target the center column here, but if your income ranges all the way to the far right column, we can also assist you. And you want to measure that also based on the size of your household. You don't need to know this off the top of your head. Feel free to talk to me after. I'll put up there's some information in your folders, and I'll have a slide here that has more information about how you contact us and get in contact with us. Generally speaking, the process. So we have a process that really starts with you going online and filling out a intake form or application. If you have a problem doing that online, just reach out. We'll have either a student help you do that, or even I can help you fill out that intake form. The second thing would be in that process, it's available online. You'll get a QR code in a second here, but it's important that you fill it out as best as you can with all the information that you have, from the parcel ID to who your relatives are that you identify as heirs. The second thing is I will take a look at the application, to review your qualifications, and determine whether it is a case that the clinic can actually assist with. And then I'll let you know, obviously, what the outcome is. And then, if you are eligible, if it is a good fit, what we'll do is have a phone conversation about what your case is like, what you're looking to do as a final outcome, and then just addressing, making sure that we are able to make sure that you're understanding the process and being able to be represented. Then there is a representation agreement that I'll go over with you, that then you would be able to execute if you do agree to the terms of the evaluation, and then you'll be onboarded. And then finally, you'll have at least two students assigned to your case to help you, whether it's estate planning or if it's helping you go through the heirs property issues of probate and other things. Important, there's about a month lag. If you put in an application, you can expect about a month before you get a final say on whether or not you will be able to be a client of the clinic. And it's important to just reach out directly to the clinic if you feel that it's taking too long or you have specific questions. No need to reach out to anybody else. We can talk to you here in the clinic. We have people that are able to answer the phone and address your issues if that's your case. This is the contact information, my information, the phone number to the clinic, my email, and it's the only thing else I wanna make sure that I highlight here. This is a student-run clinic. I oversee the work that the clinics do, that the clinic students do, but it's important to also know that we also work on an academic calendar. That means that we start in earnest in mid-January and run all the way through April, and then it start back up after at the end of the summer in August and go through November. During those off times, it's just really just me working on all the cases once the students leave. So it's important to know that that will mean that there is a ebb and flow to how these cases work. But it's also beneficial to know that you have one-on-one time during those times to talk to me directly and go through the different things that you need. So definitely feel free to reach out. I'm gonna hang out to be here a little bit after we end up here, and I'm happy to talk to people as you like. Thank you.